हेलो फ्रेंड्स। तो आज हम इस वीडियो में डिस्कस करने वाले हैं सेक्शन 10 ऑफ सीपीसी विच इज़ स्टे ऑफ सूट। सो दिस इज़ वेरी important section, and this section is also known by the name Res-Subjudice. And this however this term Res-Subjudice is nowhere used in this section, but it is implied, and it is commonly used by this term only, and not by the stay of suit, but by the Res-Subjudice. So if I started with the meaning of this word Res-Subjudice, it means that the means something is already pending. The subject matter which is already pending, under consideration, we can say, still continuing, and under consideration, under judgment. So all these terms can be used as for the word res subjudice. So as from the word we can predict that it means that according to section 10, if any suit is still pending in any competent court, then the same suit cannot be filed in any another court. So, according to section 10, अगर कोई एक जो सूट है वो फाइल किया गया है किसी एक कोर्ट में और वो पेंडिंग है, उसकी ट्रायल्स जो हैं वो भी चल रही हैं, वो उसकी जजमेंट जो है वो भी पेंडिंग है, अंडर कंसिडरेशन है, तो हम उस सेम सूट को किसी अनदर कोर्ट में फाइल नहीं कर सकते जब तक वो किसी एक कोर्ट में पेंडिंग है. तो दिस इज़ द मेन पॉइंट ऑफ दिस सेक्शन, बट there are some conditions for this section to apply, like the parties must be same in both the suits. The parties and having the same titles, the parties must be same, having the same titles, they have the same titles during filing the both the suits, and the matter should be directly and substantially in issue in the later suit should be same as the in the previous suit. So these are the main aspects of the section 10. So now if I talk about the essentials to apply the section 10, or we can say the essentials of res subjudice are, like, first one is the former instituted suit must be pending in court having competent jurisdiction. So जिस कोर्ट में जो सूट है वो पेंडिंग है, उसकी वो कोर्ट की कॉम्पिटेंट जुरिस्डिक्शन होनी चाहिए उस केस को ट्राई करने के लिए. अगर उसकी कॉम्पिटेंट जुरिस्डिक्शन नहीं है और वो पेंडिंग है उस कोर्ट में, और दूसरा सूट जो है, सेम सूट जो है वो फाइल किया जाता है दूसरी कोर्ट में, तो उस पर रेस सबजुडिस नहीं लगेगा और वो दूसरी कोर्ट उसको ट्राई कर सकती है. एंड सो competent jurisdiction of the court must be there of the previous court. Now the second essential is both the suit must be between the same parties. For the suits, both the suits, there should be the same parties in having the same title. Parties must be same. The case should be between the same persons and not any another. And the third is matter in issue. The matter in conflict between the parties must be same, or we can say directly and substantially same. So it is related directly and substantially. Word is here. So matter in issue in the subsequent suit shall be directly and substantially in issue in the previously instituted suit. Matter in issue must be same. Same parties must be there, same title of the parties should be there, and the court should have the competent jurisdiction. And if all these conditions are fulfilled and still pending in the court, and another suit for another suit for the same matter is filed, then on the subsequent suit res subjudice will be applied. So now there is one case, Madan Mohan versus Geeta Bhavan 2007, Uttarakhand High Court. So in this case only one of the issue was identical and not the other. So जो सिर्फ एक ही इशू जो था वो आइडेंटिकल था एज दैट ऑफ द प्रीवियस सूट एंड not the whole matter. So the court held that it cannot be said to be substantially the same. If only one issue is same, then we cannot say that the suit is substantially same. So stay of suit, or we can say the section 10, cannot be ordered and in this case. So the court in this case said that there must be substantial identity of matter to apply section 10, that is res subjudice to any suit. So if I talk about the what are the objectives of section 10, what are the objectives of res subjudice. So this was discussed in a case. Objectives of the section 10 is discussed in the case Indian Bank versus Sun Corporation Marketing Federation Limited 1998 Supreme Court. In this case, objections of section 10 were let down by the Supreme Court. So the objectives are that the first one is the to avoid parallel litigation, for the same cause of action. And the second, we can say, the protect a person from multiplicity of proceedings and protect the person from harassment. And the third, we can say that to avoid conflict of decisions of both the court. And we can say that if there is no section 10, then litigants kept on filing suits everywhere and there would be complete chaos in the civil courts. So to protect the courts from all these instances, for all these matters, section 10 is necessary. Now if I talk about the exceptions and when, or we can say that when section 10 will not apply, is that if any suit for the same cause of action is pending in the foreign court, then it will not apply. Then if the suit is pending in any foreign court, then for the same matter in Indian court it can be filed and the trial can be begin. So and the second exception is that the subsequent, if it is filed for the interim orders, then the court can can order interim orders in the, and the on the interim orders the res subjudice will not apply. And this the interim orders can be passed by the subsequent court, and this was held in the case again, the Indian Bank versus the Corporation Marketing Food 1998 Supreme Court. So today we have done the definition of the res subjudice and various essentials and one case law and various case law we have discussed, and objectives of the section 10 is very important, and we also discussed the exceptions. So this was all about the section 10, that is res subjudice. So here we are concluding this. So now in the next video we will discuss about the res judicata, which is also very important topic. So in the next video we will prepare that. Thank you.